Hi, I'm Jon Caldara, president of the Independence Institute and your devil's advocate. A little later in the program, I don't know how I'm going to get through it. A performance artist, poet, Christian, help me through. But until then, something I can actually get my hands around, the law. Will kind of introduce our scholar on constitutional studies, Rob Natelson. Glad to have you here.
Good to be here, John.
I wanted to bring you in because you in the world of lawyers, and I know very little about this, you just did the impressive, you like won the Masters tournament in that you've been cited several times in a couple Supreme Court cases. Now, from what I've been told by people who are throwing fig leaves at you now, that this is a really big deal.
I'd like to know what they're trying to cover with the fig leaves.
That's the point.
It is a big deal. I mean, it's not, at least for me, it's the gold ring of constitutional scholarship to get cited by the Supreme Court. It doesn't happen very often to any one legal scholar.
How many times were you cited?
12 times in two separate cases.
12 times?
12 times in two separate. And John, this comes on top.
Do you ever go to a singles bar and go, I've been cited 12 times?
That will get me about
in this case.
That'll get me about as far as most of my other lines did.
Okay. Well.
But this actually comes on top of what happened last year in the Obamacare case, when the Independence Institute brief that was based upon research that I had done was apparently relied upon by Justice Roberts in the part of the case where he said Obamacare wasn't valid. So we're very happy over the Independence Institute, as you're well aware.
Yeah, you're doing all sorts of things that I don't understand at all, but I keep hearing it's big stuff. All right, so bring it down to a level that even I can understand. When it comes to politics, it seems to be off and on. Either this bill passes or it doesn't, and it's off. Either the gov or the president signs it into law or he doesn't sign it into law. But when you get into the area of law, it becomes this big, mushy, weird thing you can't get your hands on. Well, it depends on this, and this court reads it this way, but the Eighth Circuit reads it that way, but we can take this court. And there is no yes or no. Every question in law seems to be, well, it depends. And
well, you know, John, that's not unique to law. I mean, sometimes it's awful hard for me to get a straight answer from an automobile mechanic as to, for example, what really is going to be required under what circumstances. Law is a complicated area, but it's an important area because it provides the guidelines by which people regulate their behavior. And we've had a long experience saying without law, you can't have a very effective working society.
And the idea of law is that it applies to everyone equally. The rule of law is...
That's the ideal, yes.
What affects me affects you. Let's talk about a couple of these cases. Now, you didn't write these law articles in order to be briefs in a case, is that right?
That's correct.
All right.
Yeah.
Because sometimes you can write a brief saying, I'm going to weigh in on this case, and you did that on the Obamacare case.
Yeah.
And we believe that holding Medicare dollars ransom for using Obamacare is unconstitutional. Here's why, and the court agreed with you.
Yeah.
But on some of these other things, let's do the Indian case, because that one fascinates me. You're a constitutional scholar. You spend a lot of time going backward in time, trying to figure out what they meant when they wrote the original documents.
Yeah.
How do you do that?
Well, it involves first reading the Constitution itself very carefully, knowing the 18th century language, which is sometimes different from the language we use, consulting 18th century dictionaries, for example, a lot of immersion in the literature of the time, looking at sources that explain the Constitution, of which the most famous are the Federalist Papers, but there are far more sources, and some people would say more important sources than the Federalist Papers. One thing I've been able to bring to the table that hasn't been done much is a knowledge of 18th century law. You can think what you like. You can think what you like about you can think what you like about lawyers, but the fact is most of the founders who wrote the Constitution were lawyers, and very good ones. And so the 18th century law helps shed light on the Constitution.
When you say that, I know you've actually taken trips to England.
That's right.
To go back and look at old Archie comics or something.
That's right. Semester at Oxford. I mean, I spent.
But what did you research back there? You're going back and looking at really old original documents, aren't you?
I am, and I'm looking particular at law books, for example. Several of our important founders, John Dickinson, John Rutledge, for example, studied in England. And I had the pleasure of working in exactly the same library they worked mulling over exactly some of the same books that they used.
Not reproductions, the
No,
exact,
no,
the exact books.
the real 18th century books.
Did you have some librarian looking over your shoulder? Did you have to wear
betcha,
gloves and all the rest?
You bet I did. Not gloves, but they had a complicated system there of holding the book and making sure it wasn't damaged.
So you ever take
No flash bulbs.
Do you ever take out your highlighter and go, "Hey, that's a good point"?
Good way to get exiled very quickly.
So bring it to the Constitution. So in order to understand the Constitution, and by the way, your book, the original Constitution, get it, it's good. You go back and you have to look at the Constitution from the eyes in which the founders wrote it. So you spend a lot of time making sure that the language that they use is understood today.
Yeah, not just those who wrote it, but actually more importantly, those who ratified it. There were 1,648 delegates to state ratifying conventions in the 13 states that ratified the Constitution. How did they understand it? And there are debates that are still available to read, to understand how they interpreted particular clauses.
All that seems really ethereal. And lawyers like to chat. They're kind of like rabbis. They like to stay up and argue about.
It's a lot like Bible study, actually.
Yeah, you have all sorts of great esoteric arguments that get very heated about things that that doesn't get food on the table. It's a good argument, but really, these arguments impact people's lives.
They sure do.
The Obamacare argument and what happened there changed everything. And let's talk about this Indian case. Yeah. The Constitution talks about the Indians or the Indian nations. How do they put it?
Well, first, the Constitution allows Congress to form treaties, and not Congress, but the federal government to form treaties, which they did with the Indian tribes up through the late 1860s. And then, in addition, there's a clause in the Constitution which says that Congress shall have power to regulate commerce with the Indian tribes. Now, if you get involved at all in Indian federal relations, you learn very quickly that this power to regulate commerce among the Indian tribes or with the Indian tribes is interpreted by Congress to give Congress complete power over the Indians. What my study showed, the one that was cited by the Supreme Court, is that's not true. And the particular case involved a little baby girl. A little baby girl had been put up for adoption. Her dad had given up his rights. He had decided not to marry the mother. And she had been living with his adoptive family for 2 years. And all of a sudden, the dad said he wanted his daughter back. Well, under South Carolina.
Let me get this straight.
Yeah.
So, man gives up parental rights.
Yeah.
Foster parents adopt a child.
That's
Child's
right.
been there for 2 years.
2 years.
Builds a bond with that family. And then dad says, I changed my mind 2 years later. I want my daughter back.
My daughter back. So he lives in South Carolina. South Carolina says, no way. So he points out that the daughter is, get this, 1.2% Cherokee. And because she's 1.2% Cherokee, apparently the tribe would recognize her as a member. That triggers a federal law, he says, that overrides South Carolina law and enables me to get the kid back. The Supreme Court said, no way. Justice Alito wrote a decision saying we don't have to interpret the federal law that way. And Justice Thomas, and here's where my quotation comes in, Justice Thomas says, look, if we interpreted the law that way, it would be unconstitutional. And he cites my article for explanations as to why.
That's so cool.
Yeah, it's neat.
So because of that, and because of the article you wrote before the case went on, this kid gets to stay with the adoptive parents.
The only home she had ever known.
So help me understand how this works, because you guys, and Dave Coble does the same thing, spend a lot of time tapping out words, and you get really excited because it's gone into the Pittsburgh Community College Legal Library Review, and I'm thinking, yeah, that's great. Could you actually do something positive? But I mean, that came from the University of Pennsylvania Law Review, basically.
Yeah, Journal of Constitutional
Law. So how does that work?
You basically notify editors of the different law journals around the country of the availability of the article. You write a letter touting the article, you tell them where they can read the article online, and they contact you. In this case, this is a very good journal. They publish a lot of good stuff. They like the article for some reason, and it got published.
There's no centerfold. There's no pictures. There's no crossword puzzle. This is crap.
Believe me, I have written law review articles with pictures, and I've actually had some difficulty getting the pictures in the article because it's so unusual. But that one doesn't have any pictures.
So when the Supreme Court is looking on the issue, such as the one about the baby who was 1.2% Indian, they send their minions out to scour review articles and law review articles to bring them scholarly information on which they can use or ignore if they wish, right?
That's right. Each justice of the Supreme Court has 3 law clerks, generally very bright young people who were not far out of law school. And they're very good researchers. And so that's exactly what they do, John. They scour the law reviews looking for guidance. Now, one reason I wrote this article is simply because there wasn't a lot of material out there. By the way, I should clarify, the Indian article was actually in the University of Denver Law Review.
Sorry, the one with the one with a prettier picture on it.
And that's by happenstance. I didn't specifically did it because of my connection to Colorado. They liked the article and they accepted it. The other one.
Do law reviews pay you to do this, or is it such an honor to be published that you just give it to them?
I wish. But in fact, law professors, which I was at the time, get paid very well relative to other professors, in part because they are expected to write this stuff for no additional money.
That's part of the publisher parish.
Yeah, that's exactly right.
All right.
That's exactly right. Now, the other one is also an interesting case. It involves controversy. State of Arizona said, if you want to vote in Arizona, we want to see some kind of identification proving you're a citizen. The Fed said that's inconsistent with our law, and it was a battle royal over the question of whether Arizona law or whether a federal law should control.
So stop there for a second. Isn't that part of what the founders intended?
Yes.
That not only, since our government was based on distrust of government, knowing that government overreaches and becomes over time tyrannical. So we split it up into those 3 branches that are supposed to be able to fight each other. But then there was something else. We split it up, a federal government and the states. So if the federal government goes out of control, and heaven forbid that could never really happen, that the states could step up and say, no, you're getting too big. That's the case. So this is one of those examples of Arizona versus the feds.
Yeah, in this situation, there is a federal enumerated power, the specific power in the Constitution giving Congress the power to regulate federal elections, and Congress used that power. The problem in the case that came into conflict with another provision in the Constitution stating that the qualifications of voters is up to the states. So they had to resolve that. They decided it in favor of the feds. Justice Scalia, usually identified as a states' right man, actually wrote the opinion deciding it in favor of the feds. But Justice Thomas said, hey, look, I don't think that the federal power should be read that broadly, and that's where he goes into my article and explains why. I didn't write the article for the case. The article is not about non-citizens voting.
So how did the case turn out? Who won?
The majority won, as it always is. In this case, Scalia arguing that the federal law should control, and that therefore Arizona could not force prospective voters to come up with birth certificates and other proof that they were citizens.
Incredible. Congratulations.
Well, thank you.
And if these ever come out in comic book form, I will read them.
That's great. Or we'll do an animation at the Independence Institute and put it on the web.
Do a little performance art of them.
Yeah.
Which, by the way, you're going to enjoy. Stay tuned.